There are two things that are certain, they say, death and taxes. My name is Mbonisi Ndlovu, and today I will be discussing Wills and Estates, Part 2. Previously, we did discuss the different requirements for having a valid will. There are various clauses that you can actually include in your will. It's not a limited list. However, I will mention just 4 of them, which we recommend are the most essential ones to have a valid binding will. The first one is a declaration. A declaration simply states that this will that you've just drafted is your last will, nullifying the previous ones that you've had before, basically making this one the most recent and most binding will there is should you happen to die. The second one is a revocation clause. A revocation clause simply revokes or cancels or terminates any other will that you may have had previously, or perhaps you may even revoke a specific clause in your previous will. So essentially, you are able to cancel all other wills. So it's important that you do so. In case upon your death, there are 2 wills that are in your name, and there's no certainty as to which will is actually your last and final binding will. If in that instance, the master of the High Court will read both wills as though they are yours. So it's important to state in your will that this is my last will. Any other will not have any force and will not be binding, right? And then you can also appoint an executor. So you get to choose who you want to stand in your stead and distribute your assets. In this specific clause, it's important to also highlight whether you'd like your executor who will be distributing your assets to actually issue security to the master. So by issuing security, it's simply giving insurance to the master to say, I will execute my duty as the executor with high skill and no gross negligence. And lastly, the most important one is that in your will, you can actually nominate who your beneficiaries are. So this is a clause that you have in your will to state who your beneficiaries are and also state what they can actually inherit. That is, what portion of your estate or perhaps your assets or your belongings. If you want to actually give a beneficiary a specific item, you can absolutely do that by simply stating that I would like to give a specific belonging of mine. Who can inherit in your will? Anyone can inherit in your will that you've specified in your will, right? Any person, doesn't have to be blood related. However, there must not be disqualified people. We'll see that just now. Your beneficiaries need not be related to you. So if you happen to not want to benefit your close blood relatives, you can absolutely give your assets to a neighbor, to your helper, to an animals foundation, to a legal entity. One thing that you cannot do, however, is that you cannot leave your entire estate or perhaps your entire belongings to a dog or a cat. You can, however, leave it to an NGO that protects who cannot inherit. A person who signs your will as a witness, right? Secondly, a person writing the will on your behalf. Thirdly, the bloody hand. This includes anyone who kills the testator and who duly influences the testator. So as you can see, these are the people who may have had an influence in your will writing or perhaps will drafting. So they are actually automatically disqualified. So it's important that if you draft a will, you make sure that your beneficiaries are not your witnesses, because they will be privy to your will. They will see the contents of your will, and should one of your beneficiaries actually kill you, they will be automatically disqualified. So it's important that if you are drafting a will, you do not actually tell your beneficiaries that they are actually beneficiaries to my will. And a person who also writes your will, say for instance, you are mentally, or perhaps you are unable to write, or you cannot see, or perhaps you are incapable of actually writing your own will, then you can actually get somebody to actually write your will on your behalf, to state your expression, to expressly state what you wish for your belongings to be, distributed. There is what they call a joint or mutual will. So what is that? A joint or mutual will is where two persons come together and, with the same terms which apply to both of them and draft a will. So essentially what it is it's common amongst spouses, right? But not limited to spouses. These are two wills, right? Two wills with exactly the same contents, but for two different people. I often call it a single, each person has a will, but they decided to use one document. This is common amongst spouses, as mentioned. However, it's not limited to spouses. If you happen to be business partners and you equally share things because of a legally binding document. As mentioned, it's very much practical for spouses married in community of property. The disadvantage is that when a joint will with one of the spouses dies, or perhaps one of the parties or the testator, the will maker dies, one of them dies, what will happen is that the actual will has to be lodged. That is, it has to be submitted at the master's office, where all wills of deceased people have to go for the master to actually regulate that whole process from death until all assets have been distributed. Now, there are very high possibilities of that specific will being lost. So what happens to the person who survives the spouse or perhaps the deceased will maker who also had a joint will with that specific person? So it's very important to sort of like consider that. I often advise my clients to actually have a duplicate original. So they'll both have the same will where they both mutually benefit each other and have both their assets exactly the same. And another thing that you must note is that upon the deceased's death, you are very much entitled to draft a new will when the deceased is no longer around. So it doesn't quite preclude you from actually amending the terms of your will because you've entered into a joint will previously. Now, you want to amend a will, right? Very much possible. What you need to do is to comply with the legal requirements of a valid will. As discussed in the previous video, you're welcome to go check it out. Secondly, you must have a cancellation clause of other wills. As mentioned previously that in the previous slides, that you must have a revocation clause which cancels specific clauses or specific wills. If you happen to have 3 wills, you're welcome to delete or cancel 3 or 2 of them and say the one dated on 14th of May 2019 will be my last, and then this one will be an additional will. So essentially you can do whatever. It's called freedom of testation. In other words, freedom to be a will maker. So a codicil is simply a document which specifically changes a specific clause in a will, not the entire will. The manner in which you are married during your existence as the will maker will most certainly have a bearing in the manner in which your assets are distributed upon your death. For instance, if you happen to be married in community of property, whatever that belongs to you is equally shared between yourself and your spouse. So you can never own something with the full 100% share. So whatever that is yours will equally be your spouse's. Secondly, should you happen to be married out of community of property without accrual, then there will not be any claim against your estate because your spouse has no legal right over your assets. And finally, should you happen to be married out of community of property, means upon your death, there will be an estate that has
has increased in value. The smaller estate will most certainly have a claim against the bigger estate. So if you are the deceased and your estate has shown a bigger growth, then your surviving spouse will then have a claim against your estate upon your death. To find out more about marriages and their legal implications, you most certainly can check, you're most welcome to actually check it out on our YouTube video. We hope that you enjoyed this video, and we will certainly be making another video, part 3, which will be talking about consequence not having a will.
We hope you enjoyed the presentation. Please like this video and subscribe to our channel. Press the notification button to be notified as soon as we post new content and videos. See you next time for your essential dose of legal knowledge.